Good afternoon. I am Shanu Narayan. I work with National Law University and Judicial Academy, Assam, as visiting faculty. The topic which is assigned to me today to discuss on the module is LGBT rights, lesbians, gay, bisexuals and transsexuals' right under the paper International Human Rights Law. Let me begin with the module. I have the whole module divided into 4 sections. First, an introduction. The next is evolution of human rights principles on protecting the rights of the LGBT community, the efforts of which shall be in detail discussing the efforts of the UN Human Rights Committee through case laws, through assessing state periodic reports. Next is the Yogyakarta principles, followed by UN Human Rights Council's latest resolution, this 2014 resolution, and lastly Indian legal position. I would wrap it up with a short summary. Let me introduce the subject indeed. The modern day society faces various challenges with regard to protection and promotion of the fundamental human rights of the individuals, especially in relation to individuals who are discriminated because of their diverse sexual orientation and gender identities. It is essential to decipher how concrete societies and legislations have dealt with the claims of lesbians, gays, bisexuals and transsexuals, LGBT in short, in their attempt to gain social recognition. The Western scholarship is much evolved in terms of addressing these issues of gender identity and sexual orientation, which are embedded in criminal laws, discriminatory practices and so on. It has been reflected and integrated in Western scholarship, which focuses on gender arrangements and have been regulated through soft laws and social customs. Examples of such scholarships could be drawn from the works of Michel Foucault, Judith Butler, Janet Haley and so on. Foucault's findings are premised on the argument that real or true or original sexual identity is an illusion and that sex is only one component of omnipresent power mechanisms. Judith Butler, drawing from this analogy, states that sex is a biological category on the one hand and gender is culturally constructed on the other. Since the past 2 decades, the international community has witnessed various efforts by international human rights activists and lawyers who have been vehemently arguing for combating all forms of discrimination and violence against sexual minorities. The gamut of international human rights law, which is IHRL, have become inclusive and mindful of the need to address the issues concerning individuals who identify their sexual orientation and gender identity within same-sex, bisexual or transsexual relationships. Historically, people belonging to the LGBT groups have experienced various human rights violations such as violence, harassment, discrimination, exclusion, stigmatization and right to privacy. Further, such violations also include killings, rape and physical attacks, torture, arbitrary detention, the denial of right to assembly, expression and information and discrimination in employment and health sectors. Basis of penalizing such sexual acts or penalizing such sexual minorities, as has been argued by the anti-LGBT supporters, is basically on the grounds of immorality, deviant behavior and indecent behavior. Now, more than 80 countries in the present day world have premised homosexuality as a criminal offense. The national laws criminalizing such behavior considers it either as sodomy, public scandals or immoral or indecent behavior and thereby are used to penalize people for looking, dressing or behaving differently from embedded social norms. Let's come to the efforts of the UN Human Rights Committee in addressing the issues of the LGBT community. Article 2 and 26 of the International Covenant of the Civil and Political Rights 1966 has been the most interpreted articles under the international human rights law, which discusses on the LGBT rights. For example, in 1994, 2 decades before, we had the Toonen versus Australia case, which challenged the sections 122 and 123 of the Tasmanian Criminal Code and held that, in which the UN Human Rights Committee held that it violated the right to privacy and right to non-discrimination as enshrined in the ICCPR. This decision deviated from the prior international jurisprudence on prohibition of same-sex relationships by innovatively reading the principle of non-discrimination on the grounds of sex under Article 2 as including sexual orientation, thereby expanding the gamut of, or rather reading concept of sex as sexual orientation also within the human rights regime. Coming to the issue of right to marry, we had the famous Jocelyn versus New Zealand case, in which the question on the right to marry, privacy rights and equal protection of law as enshrined in the ICCPR was interpreted, and the committee, while interpreting Article 23 of the ICCPR, stated that it applied only to the union between a man and a woman. Hence, it completely ruled out civil partnership. However, in the later decision in 2003, the committee held that the equal protection of law shall be applied to civil partnership as well, because it took a remarkable approach towards recognizing civil partnership under Article 26 of the ICCPR by virtue of expanding the concept of equal protection of law as read under the article. We have the International Covenant on Economic, Social and Cultural Rights 1966, which also premises that non-discrimination and equality are the fundamental components of international human rights law and are essential to the exercise of full enjoyment of economic, social and cultural rights. By virtue of General Comment 14, 15 and 20 of this Committee on Economic, Social and Cultural Rights, the terminology other status as enshrined in Article 2 Para 2 was expanded to include sexual orientation status as well. That stands as a remarkable approach in the whole jurisprudence of international human rights law in terms of LGBT rights. The second subsection under the evolution of human rights principles on LGBT groups discusses on the concluding observations of the state parties' periodic reports. The UN Human Rights Committee on its work in relation to the rights of LGBT people has deduced the concluding observations of the state parties through their periodic reports, which in the past 10 years, if we have a cross check, it clearly states in terms of complying with Article 2 and 26 of the ICCPR that there is a positive approach, and these observations are categorized as anti-discrimination measures and this decriminalization of homosexuality and homosexual activity through repealing or amending various legislations. The concluding observations of the state parties' periodic reports explains, or rather widens the concept, because in 2009 we see that the nomenclature of LGBT was used for the first time, which expanded this construct of term sexual orientation, and it widened the scope of the term to include, or rather to give a clear idea of LGBT rights or clear nomenclature as LGBT rights. It again emphasized on the sexual minority rights. In 2012, the committee mentioned in its concluding observations that intersex persons also intended or needed to be expanded, because it should be LGBTI, which includes intersex also, wherein I denotes that it attaches great significance to greater sensitivity to the diversity and dispersed nature of sexuality. Having said that, let's now move on to the Yogyakarta principles, which is a soft law in the making, in fact. A decade after the Toonen's decision in 2007, the Yogyakarta principles on the application of international law in relation to issues of sexual orientation and gender identity was adopted in March 2007. These principles were adopted by a distinguished group of international human rights experts. The attempt was to outline a set of internationally binding principles relating to sexual orientation and gender identity. However, it still remains a mere initiative by the civil society group, which does not include participation by the states. Now, coming back to the content of the Yogyakarta principles, it consists of 29 principles, and it gives a paramount importance to universality and inalienability of human rights, devoid of sexual orientation and gender identities. It is based on the theory of rights-based approaches, which entrust the state bodies with duty to implement the legal obligations, such as taking all necessary legislative, administrative and other measures to eradicate impugned practices which discriminate and violate the basic human rights of the individuals with diverse sexual orientation and gender identities. Secondly, it undertakes protection, it requires states to undertake protective measures. Thirdly, it ensures that accountability of perpetrators must be there, because if there is a violation of the basic human rights of the LGBT community, there is a need for redressal for the victims as well. Fourthly, promotion of human rights culture by means of education, training and public awareness raising. So basically we have four major issues, or rather four major obligations which is entrusted on states by virtue of the Yogyakarta principles. Firstly, it requires states to take necessary legislative, administrative and other measures to eradicate the impugned practices which discriminate and violate between the sexual minorities and the majority. Secondly, it requires state to take protective measures. Thirdly, it needs, or rather it requires states to ensure that perpetrators of the crime are accountable, made accountable before the law. Lastly, there should be a culture of promotion of human rights by means of education and public awareness. The preamble of the Yogyakarta principle defines the term sexual orientation and gender identity. The term sexual orientation, as in the Yogyakarta principle, it reads so. It says, sexual orientation is understood to refer to each person's capacity for profound emotional, affectional and sexual attraction to and intimate and sexual relations with individuals of a different gender or the same gender or more than one gender. Gender identity says it is understood to refer to each person's deeply felt internal and individual experience of gender, which may or may not correspond with the sex assigned at birth, including the personal sense of the body, which may involve it, if freely chosen, the modification of bodily appearance or function by medical, surgical or other means, and other expressions of gender including dress, speech and mannerisms. An overview of the Yogyakarta principles reflects an attempt by the defenders of the LGBT groups of their fundamental rights to life, freedom from violence and torture, privacy, access to justice, fair trial, to be treated with humanity while in detention, and freedom from arbitrary detention as it is dealt between for principles 4 to 11. Another important provision that needs explanation is protection against all forms of trafficking, sale and right against exploitation. This provision acknowledges and takes into account the vulnerability of people with diverse sexual orientation due to discrimination and inequality that they faced based on sexual exclusion, which might lead them to fall prey to trafficking and exploitative measures. Hence, we see that there is clear nomenclatures or clear classification of the laws and the violations which could probably happen. Next is in terms of right to work and social security measures. Principle 12 to 18 of the Yogyakarta principles outlines the importance of equality and principle of non-discrimination towards full enjoyment of economic, social and cultural rights, especially in terms of right to work, social security and other protection measures, adequate standard of living and housing, education, health and protection from medical abuses. The key aspect on the right to attainment of highest standard of health requires states to ensure access to healthcare facilities, goods and services, especially in relation to sexual and reproductive health and to their own medical records. The next is the right to freedom of opinion and expression, which includes expressing one's own sexual identity or personhood through speech, deportment, dress, bodily characteristics, choice of name or any other name. Such expression means or mentions or rather recognizes the practice of cross-dressing by the drag queens and drag kings, who may choose any medium for expressing their queer identity as their identity. The principles from 19 to 21 also ensures notions of public order, public morality, public health and public security, which are not to be employed in a discriminatory manner to restrict the rights of the LGBT community to express themselves of their diverse sexual orientation and gender identity. Such freedom of expression extends to their right to freedom of peaceful assembly and association, including for the purpose of peaceful demonstrations as well. The right to freedom of thought, conscience and religion and movement and residence within the borders of a state, thereby obligating states not to impede in such persons entry, egress or return to or from any state, including that person's own state, is also recognized. Principles 22 to 29 is comprehensive enough to state that state must ensure rights of such persons to seek asylum from persecution. These principles are followed by the rights of persons to participate in family life, public affairs and cultural life of their community. Quote, community. The crucial principles are enshrined in the principles 28 and 29, which affirms holding perpetrators of these crimes or these violators of these rights to be accountable for their acts in order to ensure appropriate redress for the victims belonging to such diverse sexual orientation and gender identities. Now, in this light, what is more important is when you read the whole Yogyakarta principles, different or varied rights which is enshrined in all the constitutions, most of the constitutions across the world is guaranteed or rather dealt with. Now let us look at the recent UN Human Rights Council's resolution. On 24th September 2014, the UN Human Rights Council at its 27th session adopted a resolution titled Human Rights, Sexual Orientation and Gender Identity. This resolution, via its preambular paragraph 3, stated that significance must be attached to national and regional peculiarities and various historical, cultural and religious backgrounds, which must be borne in mind if it is a duty of states, regardless of their political, economic and cultural system, to promote and protect all human rights and fundamental freedoms. Now, it clearly states that states can respect their political, historical, cultural and religious backgrounds. Thereby, when a state recognizes their own national and regional peculiarities, it can lead to assertive discrimination as well. Now let us look at what is the Indian legal position. The Indian judiciary at length discussed on decriminalization of homosexuality as enshrined in section 377 of the Indian Penal Code 1860, which deals with unnatural offence. In the famous decision of Nas Foundation versus Government of NCT of Delhi, wherein the High Court of Delhi upheld decriminalization of homosexuality, which is decriminalized adult consensual sexual acts in private. This was in 2009. There was a subsequent litigation which challenged this decision. However, in the NAS Foundation case, which was a public interest litigation filed to test or rather challenge the constitutional validity of section 377 of the IPC, stated that it violated fundamental rights of the people belonging or identifying themselves with diverse sexual orientation and gender identities that are guaranteed under Article 14, 15, 19 and 21 of the Constitution of India 1950, which basically says they are discriminated on the grounds of equality. There is discrimination in terms of employment, there is discrimination in terms of right to work, and there is clear discrimination in terms of privacy, right against privacy, right to privacy, and arbitrary detention. So, when you look at how the court discussed this issue, in the Delhi High Court explained that there is clear violation of these fundamental rights enshrined in Part 3 of the Indian Constitution, and therefore, Section 3, there was a need to decriminalize homosexuality, and that was something which was very widely received decision. However, in December 2013, this decision was set aside by the Supreme Court of India in an appeal by Suresh Kumar Kaushal and another versus NAS Foundation, thereby upholding the validity of 377 of the IPC. It completely overruled, or rather it completely set the case back in the same position. In March 2014, now at present, a curative petition was filed by the NAS Foundation stating that there is most glaring error in the above mentioned decision of the Supreme Court, wherein it failed to take notice of the effective amendment of the Criminal Law Amendment Act 2013 with special reference to the offence of rape as enshrined under section 375 of the Indian Penal Code. Hence, we wait for the decision. Now, on the transgender's rights, the case was brought before, or the issue was brought before the Supreme Court of India in National Legal Services Authority versus Union of India, which was decided in 2014, 5 SCC 438. It upheld their concerns, and the court declared that individuals from the transgender community, apart from binary genders, be considered as third gender for safeguarding their rights guaranteed under Part 3 of the Indian Constitution. In this light, we have the Indian court or other courts taking two diverse position in terms of same-sex bisexuals and same-sex bisexuals and transgender relations. Now, in all the three cases which I have just mentioned, the court was elaborately dealt with the Yogyakarta principles, stating that it dealt with the basic human rights of the individuals belonging to people belonging to diverse sexual orientation and gender identities. In summary, the human rights of the individuals belonging to the LGBT community are still in the nascent stage of evolution. The initial attempt by the LGBT defenders and human rights activists were to argue for social inclusion through expanding the definition of diverse sexual orientation and gender identity. The UN Human Rights Committee, which can be considered as the vanguard of protecting human rights, that is the universal and inalienable rights to all human beings, has addressed these issues within the scope of Article 2 and 26 of the ICCPR. These efforts form part of international jurisprudence on this subject, especially the Tunan's case. In the Tunan's case, it was considered as a breakthrough in this field, as the committee could declare the criminal law that penalized this social group as violative of the basic human rights of the LGBT community. Simultaneously, the general comments by the Committee on Economic, Social and Cultural Rights gradually started extending the basic rights to sexual minority by including them within the term the other status. The Yogyakarta principles, though of non-binding nature, could be regarded as comprehensive in terms of incorporating the basic human rights of sexual minorities. These principles have attempted to address various problems by this social group, primarily being right against violence and privacy. The Indian legal position has deviated from the progressive path by setting aside the decision decriminalizing homosexuality. When it comes to the Indian scenario, homosexuality, same-sex relationships, has been distinguished from transsexuality. This is manifestly evident from the decided case laws of the Indian Supreme Court, where on the one hand, criminal law criminalizing homosexuality was declared valid, and on the other hand, people belonging to transgender community were given the status of third gender. Hence, it is understood that the state needs to take proactive measures in recognizing the rights of the LGBT community. International law in this regard has a long way to go, because participation of the states in complying, or rather in making the rights of the LGBT community as essential or as paramount is becoming very important. Hence, I wish you had a good discussion, and thank you. Goodbye.